of Uganda, representing the third respondent. And together with me, my lords, I have Mr. Francis Atoke, the Solicitor General. My lords, I have Christine Kawa, the Acting Director of Civil Litigation. I have Mr. Martin Mwambusha, the Commissioner of Civil Litigation, Line Ministries. I have Mr. George Kalemera, Commissioner of Civil Litigations, Local Governments. I have Mr. Richard Adrole, the Principal State Attorney. I also have Mr. Geoffrey Madete, Senior State Attorney. We are also assisted by Mr. Brian Musota, State Attorney. My lords, the first respondent is represented by Mr. Kiriowa Kiwanuka, Mr. Edwin Karujire, Mr. Ebert Biencha, Mr. Ronald Tusingwire, and Mr. Esau Isingo. My lords, the second respondent is represented by Mr. Joseph Masiko, Mr. Ellison Karuhanga, Mr. John Jet Tumwebaze, Mr. Alfred Okello Oriem, and Mr. Eric Sabi. My lords, in terms of representatives, the Electoral Commission is represented by Honorable Stephen Tashobia, and the first respondent is represented by Mr. Oscar Kihika, who is the Director of Legal Affairs at the NRM. My lords, the applicant petitioner is represented by the Honorable Medad Lubega Segona, Mr. Samuel Muizi, and Mr. Sekanjako Abubakar. My lords, those are the representations for this morning for the application that is before you, and my lords, we are ready to proceed.
My Lord, the Honorable Chief Justice, and my Lords, the Honorable Justices of the Supreme Court. My name is Medad Lubega Segona. For the applicant petitioner, as a preliminary, my Lords, yesterday I raised the matter of the issue of a professional nature, and we want to express our gratitude to the Honorable Court, on whose orders the process of obtaining renewal of our practicing certificates was expedited and successfully concluded for the three advocates appearing before your lordships this morning. We are also grateful to the registrars of this Honorable Court and the Chief Registrar, as well as the Law Council, which complied with the directive and did the inspection of chambers in a record time. We have accordingly proceeded to submit evidence of the practicing certificates to court with the copies to council. My Lords, with that and with your permission, I pray that you permit me to proceed with the application.
How much time do you need to make your submissions?
Lords, in terms of the time I need, I think between 20 to 30 minutes.
Yeah, you're telling us why you want to withdraw, not so?
Yes, my Lord.
I was thinking you would tell me 5 minutes.
In 5 minutes?
No, that's what I thought you were going to tell me.
No, I did not intend to tell you 5 minutes because it is certainly not enough, because there's one issue which is contentious.
Court is giving you 20 minutes.
I appreciate, my Lord.
Please operate within the 20 minutes.
I appreciate
that. That will be for everybody.
Thank you, my Lord.
Yes, yes.
My Lords, this application is brought by the applicant under the provisions of the law stated. It seeks for orders of this Honourable Court to permit the applicant withdraw his petition, number 1 of 2021, and it is accompanied by 2 affidavits. The first being his affidavit, sworn by the Honourable Robert Sentamu Kyagulanyi, and supported by the affidavit of his advocate, one of his advocates, as a further additional affidavit of Ukasha Sekaja, my lords. The grounds are also listed in the application as well as the supporting affidavits. My lords, the first part of the affidavit or grounds in support of grounds 1 to 5 explain the background. But the gist where I want to put emphasis, as required by Rule 20, Sub-Rule 3 of the presidential election petition rules, is with respect to rule, is where I lay emphasis. My lords, the petitioner states, stroke applicant states that his decision to withdraw the petition has been influenced by the grounds foregoing, that is 1 to 5, and that it is not motivated by any corrupt bargain or consideration from the respondents or any other person. This he restates in his affidavit in particular paragraph 20 of the affidavit in support. And my lord, this is reinforced by the affidavit of Mr. Ukasha Sekaja, but also confirmed by the respondents in their 3 affidavits in reply, that to the best of their knowledge, just like the applicant, the decision to withdraw is not influenced by any corrupt motive. To this extent, my lords, it satisfies the requirement under Rule 20, Sub-Rule 3 of the Presidential Election Petition Rules, 2005. My lord, to be particular for Ukasha Sekaja's application, the affidavit in support of the motion, I am referring to paragraph 4 and 5 of the same. My lord, the power to withdraw or to permit a withdrawal is a power and a discretionary power of this Honourable Court. I invite this Honourable Court to consider the grounds in the application and the affidavits and permit the applicant to withdraw the petition for the reasons given. My lord, the second leg, which appears a little more contentious, is the question of costs. I have had occasion to discuss with counsel for the respondents with a view and bargain, not a corrupt one this time, but with a view and bargain that they concede to costs in terms that each party bears its costs. I have not received a positive answer, and their view is that they should be paid costs. In particular, I'm referring to first and second respondents. My lord, the law on costs with respect to withdrawal of petitions under the Presidential Elections Act and the rules is found in Section 61, subsection 4 of the Presidential Elections Act. It reads, and I quote, "If a petition is withdrawn, the petitioner shall be liable to pay costs to the respondent. The rules, my lords, particularly Rule 20, Sub-Rule 8, provides in similar terms that if the petition is withdrawn, the petitioner shall be liable to pay costs to the respondent. With your permission, my lord, permit me also to refer to my lords first, if I may seek your indulgence. Yesterday I was meant to apply to have our bundle of authorities admitted, which was not done because of the circumstances of yesterday. May you permit me at this juncture to pray that you permit the authorities that we presented, the bundle of authorities that we presented yesterday, and these were 6, together with an additional my lords, with your permission, with just one additional authority, and from there, with your leave, I will proceed to make reference to them.
This is the one dated 4th of this month?
3rd, my lord. 4th, my lord.
Applicants index of authority.
Yes, my lord. It is filed on 4th, which was yesterday.
Yes. Lord Attorney General, what's the view from the respondents? Can you address us on?
My lord, with just one additional loose authority.
No, but just a moment. Had you served them? When you filed it, did you serve the respondents?
Yes, my lord, we did.
When?
Yesterday.
Yesterday.
Yes, my lord. We were served yesterday.
Yeah.
And we have no objection.
You have no objection. Performed. So I suppose you speak for all the respondents. Yes, Mr. Kyo.
My lord, we were indeed served with the bundle of authorities, 6 of them. Just the loose one, we don't know which one that is.
Oh, you were not served with this document?
We got the bundle, but he mentions another authority, one more authority, which we haven't received.
Mr. Lubega, is it contained in this?
No, my lord. It is not contained. But
how does it look like?
It looks like this, my lord. I don't know if you'll be able to see it from a distance. It is not on your record, my lord.
Oh, it's not on the record?
This one is not on your record.
Oh, you intend to file, to submit another one?
Yes, my lord. Just one more.
But you did not avail them?
No, my lord, because this is an authority we picked this morning.
Yeah,
but we are happy to serve them.
No. You see, Mr. Lubega, the moment you get an authority, you don't need leave of court. The first thing to do is to avail the other side. Even if court were to refuse, at least you've been gracious enough to avail the other side. Then they have something to say.
My lord, I receive your guidance with gratitude. Thank you.
Attorney General, what do you say? I have not seen the authority. You've not seen it. What do you say?
Does the counsel for the applicant intend now to serve us right now? Yes, then
yes, my lord.
Okay. Is it a Ugandan authority? Or?
It is a Ugandan authority, my lord.
Okay.
Yes, we will be ready to.
And one of the parties is Attorney General himself.
Fine. The court will receive it, but please
serve us.
The proper procedure is when you get it, the first people to receive should be the other side. It makes it easier for you to persuade court.
We thank you, my lord.
Yes. The only difficulty, Mr. Lubega, is that that document has not been roasted, so the lordships will not receive it.
I appreciate.
You understand what I mean?
I appreciate
And I think for the good of the other side,
yes, my Lord.
We've taken note of it.
Yes, my Lord.
I don't think it's safe for counsel on the other side to...
My Lord, yes, I appreciate
I'll make arrangement with my registry to take it for roasting, and then
thank you, my Lord.
we can receive it. Roasting means it's taken in the oven to ensure that you minimize the risk of COVID-19, which is very real.
It is real, my Lord, yes. May I therefore proceed?
Yeah, proceed.
Thank you, my Lord. My Lords, having made reference to the Act and to the...
You've used 10 minutes
Thank you, my Lord.
of your time, yeah.
Having used 10 minutes and left with 10, and I'll try to summarize.
Counsel, what about the authority? What are we supposed to do with it? You haven't mentioned it. What are we supposed to do with the authority which has been taken for roasting?
Oh, my Lord, I believe by the time I get to it, they would have finished the ovening and the warming of the document. But in the meantime, if you permit, I'll proceed to the authorities submitted yesterday. My Lords, we submit that this court should find a pleasure in ordering each party to bear its costs. And the reason is that an election petition of this nature is a very important instrument of guaranteeing the safety of Ugandans in terms of democracy and rule of law. Persons aggrieved by decisions of the second respondent declaring a winner or purported winner of an election should exercise one option, which is the civil option of coming to court. The alternative to coming to court has been and has proved catastrophic in our history, and that is well represented in the preamble to our Constitution. Persons aggrieved and dissatisfied should find the route smooth to access courts of law as the final and ultimate arbiter. Only then shall Ugandans be safe and tranquility be guaranteed. This court has had occasion to consider issues of election petitions and costs in the previous presidential petitions that have been presented. Beginning with authority number 1 in our bundle, which is Kizza Besigye versus Museveni Yoweri Kaguta, now Tibuhaburwa, and the Electoral Commission Presidential Election Petition number 1 of 2001. My Lord, as there was no withdrawal in that case, and the petition was prosecuted to conclusion, this is what court had to say, and we have proceeded to highlight the relevant extracts for court. In particular, I'm referring to the judgment of Odoki CJ as he then was at page 8 of that bundle of authorities, page 8 to 9. But one important aspect that comes out...
Councillor Weber.
Yes, my Lord.
Can't be right to say Odoki CJ as he then was. He didn't attain any other thing in the judiciary after that.
Oh.
So he remains Odoki CJ.
Odoki CJ, thank you, my Lord.
For instance, if you're referring to me for a decision I made when I was DCJ, that's when you say DCJ as he then was.
Most obliged.
Because I attained something else after that.
Most obliged, my Lord. I was only misled by... It could have been a misapprehension that thereafter I became a justice of the Supreme Court after being a CJ, my Lord. Yes. With that guidance, my Lord, at page 8 of that bundle of authorities, he had to say this: it is well settled that costs follow the event unless the court orders otherwise for good reason. And that's where I come to discretion of this honorable court. The discretion accorded to court to deny successful party costs of litigation must be exercised judicially and for a good cause. Costs are an indemnity to compensate the successful litigant the expenses incurred during litigation. Costs are not intended to be punitive, but a successful litigant may be deprived of costs only in exceptional circumstances. In awarding costs, courts must balance the principle that justice must take its course by compensating a successful litigant against the principle of not discouraging poor litigants from accessing justice through the award of exorbitant costs. In the present petition, I am of the considered opinion that the interests of justice require that court exercises its discretion not to award costs to the respondents. I agree with Mr. Balikudembe that this was a historic, unprecedented case in which a presidential candidate who is a serving president, and I emphasize, was taken to court to challenge his election. The petition raises important legal issues which are crucial to the political and constitutional development of the country. In a sense, it can be looked at as public interest litigation. It promotes the culture of peaceful resolution of disputes. The petition was not frivolous or vexatious, as the petitioner succeeded in issue 1 and 2. The petition was therefore of great public importance. He made reference to others, but I'll run to the other justices who, in similar terms, ordered that the petitioner, would not pay costs. Of particular importance, my lords, is the decision of Odell JSC, A.H. Odell JSC at page 13 of the bundle. And I will only quote one paragraph that I find very crucial. Second, access to court for peaceful settlement of constitutional, political, and election disputes should be available to all, the rich and the poor, which prohibitive costs of litigation would discourage effectively. My Lord, all the justices of the Supreme Court held in similar terms with respect to Justice Sekoko JSC at pages 16 to 18 of that bundle of authorities were speaking in similar terms. My Lords, the Honorable Just Karokora JSC.
I'm giving you 5 more minutes.
Thank you,
you had eaten up your time, but I know there were interruptions.
Thank you,
so please make sure you conclude.
At page 22, my Lord Justice Karokora JSC to 24 speaks in the same terms. And Mulenga JSC at page 27 to 29 and 28 speaks in the same terms. The ratio in this, my lords, is that a person aggrieved should have nowhere else to run. And that person must not be scared of the attendant costs, because deterring a litigant from accessing court may also have catastrophic consequences for the country. I submit that an election petition is not a personal matter. That's why a person is not at liberty to simply withdraw. He has to convince you, which we are here to do. My lords, Odoki CJ, in the second authority of Dr. Kizabe CJ versus Museveni Yoweri Kaguta, election petition, presidential election petition number 1 of 2006, again a similar finding was made, and I refer to page 29 and 30 of the judgment of the Chief Justice. In addition, my lords, the other justices on this concurred. Those principles apply to the 3 respondents generally, but with particular reference to the second respondent, the Electoral Commission, my lords. The situation is made even much better and easier for this Honorable Court. In the case of Professor Arthur Peter Mutharika, a similar finding was made, and we have highlighted at page 39 of the bundle of authorities. But when you go further to Raila Odinga, at page 46, this is where there is particular reference to the Electoral Commission, which is the second respondent in our case, in addition to the principles I have already elaborated in the authorities. At page 46, that is paragraph 387 of the decision of the Supreme Court of Kenya. On costs, they write, "We're aware that costs generally follow the event, but the present petition has brought to the fore the need for IEBC, that is the Independent Electoral and Boundaries Commission, to adhere strictly to its mandate and not to exhibit the casual attitude it did in the conduct of the impending election. And in defense of this petition, it is heavily public funded constitutional organ and a burden to Kenyan taxpayers with the litigation costs would be a grave matter which we deem unnecessary in the petition. Let each party bear its costs." It is not that somebody would go away without paying costs. Indeed, the petitioner would pay his costs in this case. The first respondent has already been declared a successful participant in the election and declared to be the President of the Republic of Uganda. What more would such a person require from a citizen who has challenged him peacefully, democratically, and constitutionally? We submit that it would be unfair to gift such a person with costs from a citizen that has challenged his election. But being a public interest litigation, my lords, and with more specific reference to the Electoral Commission, the affidavit in rejoinder by Ukasha Sekaja even did raise a more important legal issue that court may find pleasure in holding that the petitioner should not pay costs for the second respondent. And this is an issue of procurement. He stated he's aware that the second respondent, in procuring the services of the advocates or the law firms mentioned, due process of procurement was not followed. And we have not received rebuttal to that extent. The PPDA, my lord, requires, that is the public procurement and disposal of public assets, applies with equal force to the second respondent, who never went through that process in procuring the services of those law firms mentioned, which Honorable Stephen Tashovia mentions to have been procured, to have been engaged. The third authority that I had intimated to court, which is going through the sanitization process of court, my lords, with your permission, and which we hope will be availed very shortly, is the decision of the High Court, which I invite you to find applicable in the circumstances, of Attorney General, the Honorable Peter Nyombi, versus Uganda Law, and the Attorney General and the Honorable Peter Nyombi versus Uganda Law Society, a decision of the Honorable Justice Musota. In particular, at page
what court was that?
My lord, thank you very much. It was the High Court. It was a decision of the Honorable Justice Stephen Musota in the High Court. And that's why.
What bearing would that have on this court?
That's why I invited this Honorable Court to adopt it and find it persuasive. Thank you, my lord. So, in particular, he reads, I agree with the submission by Land Council for the respondent.
Mr. Lubega.
Yes, my lord.
I think there's a legal word or phrase.
Sorry, my lord.
There's a legal word or phrase. How does the Supreme Court treat decisions of courts lower than it or of other jurisdictions?
My lord, such decisions are said to be persuasive
the court can find them persuasive.
Thank you, my Lord.
Turn up your time.
Thank you, my Lord. And the beauty is that
I want to know what your prayers are.
my prayers to invite this honorable court to find pleasure in allowing the petition to be withdrawn and to order that each party bears its costs. I so pray, my Lord.
Yes, Attorney General. Just a moment. Let me get back to Mr. Lubega. Mr. Lubega, what had you pleaded with regard to cost in the application? Would you like to go back there?
No, my Lord, for the costs of the application and the costs of the petition for each party.
No, in the application. This application you're prosecuting now.
Yes, my Lord.
What was your pleading regarding cost?
I pleaded, my Lord, that the costs be provided for.
Is that the same as saying each party should bear their cost?
My Lord, provision for costs, as I understand it, and subject to your guidance, is that when you provide for costs, you make your orders. And the orders I'm praying for is that each party bears its costs, both in the petition and in the application.
Okay.
I thank you.
Thank you. Yes, Attorney General.
Thank you very much, my Lord. And the Justices of the Supreme Court. For the respondents, we will start with the first respondent.
Each of the respondents will have 20 minutes or so.
Thank you, my Lord. And we'll start with the first respondent.
First respondent. Okay, thank you.
My Lord Chief Justice. My Lord Chief Justice.
Yes.
My Lord Justices of the Supreme Court. My name is Edwin Karujire.
For some reason, either you are taller than the microphone or it is faulty.
I hope I'm audible now.
No, you have to speak louder because you have a barrier covering your mouth, so you have to fight against.
I will speak louder, my Lord.
That's better now.
My Lord Chief Justice, my Lords Justices of the Supreme Court.
Would you like to sit down so that it is, because we're more interested in getting you on record?
My Lord, I'll hold this higher.
Oh, fine.
I prefer to stand.
Or you pile up books and then bring it near. Yeah.
I'll pile them up and then shout.
Okay. No, do not shout. Just.
Thank you, my Lord.
You'll have headache by the time you finish 20 minutes. Proceed.
My Lords, I'm Edwin Karujire for the first respondent. My Lords, we do not oppose the application for withdrawal of the petition. We, however, seek to address court first on the orders that are consequent upon withdrawal, but also, my Lords, we want to use the opportunity to correct some of the falsehoods that have been relied on by the applicant in support of this application. My Lords, I'll first start with the false statements and unfounded beliefs, which are typified by ground 3 of the notice of motion, as well as paragraph 19 of the affidavit in support. My Lords, ground 3 of the application states that procedural rules governing the presidential election petitions have been applied to disadvantage the petitioner and his petition, in that A talks about the dismissal, the disallowing of the application to amend, and B talks about disallowing the application to file additional affidavits. Paragraph 19 of the affidavit of the applicant states, my Lords, that after deeply reflecting upon the foregoing circumstances, I reached the decision that withdrawing the instant petition is the right thing to do, since court is not handling the petition with the independence, impartiality, and equality expected of it. My Lords, much of what has been alleged by the petitioner as partiality, lack of independence of the court, and also as harassment by the respondents is manifestly false. and it has very grave consequences, and it cannot go unanswered. However, my lords, ultimately, all this is just diversionary noise. In our opinion, one ought to simply ask 3 key questions. We need to cut through all this noise and ask 3 key questions. One is, was the petitioner afforded a reasonable opportunity to file a petition challenging the 2021 election? And in answering this, the starting point, my lords, is the law. The petitioner was afforded 15 days by the law from the declarations of results. And this was a 50% increment from the previous electoral cycle of 10 days. In comparable jurisdictions, we have markedly shorter times. Kenya has 7 days, Malawi 7 days, Zambia 7 days, Rwanda 48 hours, and Tanzania you cannot even challenge the results. My lord, there are only 2 other comparable jurisdictions which have a longer time, which is Ghana and Nigeria, which have 21 days. But in those jurisdictions, you can swear in the winning candidate while the petition is continuing. My lord, in our opinion, the 15-day period is adequate and is more than is given by other comparable jurisdictions. And this is necessary, my lords, so that we have certainty in order to prevent anarchy that a prolonged electoral dispute can bring. The next point, my lords, to answer the question of whether there was a reasonable opportunity to file the petition is to look at the facts. And the first fact, my lord, is that the petitioner got 2 extra days beyond his requested time for filing this petition. The petitioner wrote to this court seeking the opening of the registry on Saturday the 30th of January in order to file his petition. Rule 12.2 of the presidential election petition rules allows the opening of the registry on weekends by order of the Chief Justice, but this only applies after a petition has been filed and not before. The court instead allowed the petitioner to file his petition on Monday, the 1st of February, which was 2 extra days beyond his requested filing time. When the first respondent was required to file its answer, the last day fell on a Saturday. But no such accommodation, my lords, was given to the first respondent, and none was requested for either. Instead, the petitioner and his party are publicly castigated and ridiculed the court for opening on a Saturday for the first respondent to file its answer. Of course, forgetting that the petitioner got 2 extra days beyond his requested time. My lords, the court could rightly have insisted when it received the letter on Friday that Friday the 29th was the last day for filing, but it did not. So how court's accommodation, which wasn't extended to the first respondent, has turned out to be a source of attack and ridicule is baffling. My lords, the second fact is that the restrictions which were imposed on the petitioner's movement after the election did not impair his ability to file the petition, as he continues to allege in this application and in previous applications. My lords, on 6th of February, the petitioner filed an application for leave to amend his petition. He stated in the application that his phone signals were blocked from the 14th of January and his freedom of movement was restricted from the 16th of January, and that it was only after the lifting of the restrictions on the 25th of January that he was able to gather evidence and to file the petition on the 1st of February. This, my lords, is not true, as shown by the following. One is that the petitioner's own lawyer, Turiamusima Geoffrey, in his supplementary affidavit, states that he was in phone contact with his client at all times during the restrictions. We have attached the affidavit to the affidavit in reply of Mr. Oscar Chika. Honorable Zake also in his affidavit states in paragraph 41 that on 16th February he received a phone call from the petitioner summoning him to the petitioner's home in Magere. It is not therefore true that he had no phone contact with the outside world, as he falsely continues to allege. These 2 affidavits which were submitted by him show that from the 14th he was in communication with both his lawyers and his party officials. Secondly, my lord, the affidavit in reply of the third respondent in miscellaneous application number 1 of 2021 clearly showed that the averment that the petitioner was only able to meet his lawyers on the 25th of January is false. The affidavit of the third respondent, sworn by the Deputy Attorney General, attached a register book that clearly shows that he first met his lawyers on 21st of January. Therefore, my lords, in answer to the question as to whether the petitioner was afforded a reasonable opportunity to file his petition challenging the 2021 presidential election, the answer is clearly yes. He was in telephone communication with the lawyers and party officials at all material times, and this was ample opportunity for him to coordinate evidence gathering. He met the lawyers as early as 21st of January and even got 2 extra days beyond the time he said he was ready to file the petition. The second question, my lords, we need to ask ourselves in order to cut through the noise, the unprincipled noise, is, was the petitioner afforded a reasonable opportunity to present his evidence in support of the petition to this court? And our answer, my lords, is yes, and it's demonstrated by the following. One, it's by the 4th of February, the petitioner had all the old and all the new evidence that he needed to prove his case. And why do we say this? It's because in the affidavit in support of the application to amend the petition, the petitioner stated that with the help of senior officials, he had discovered new evidence that warranted amendment, and that he attempted to file the amendment without leave on 4th of February. Now, this is paragraphs 10, 12, and 14 of Chagulanyi's affidavit. Clearly, my lords, he had the evidence on 4th of February, but he did not file on this date. Another opportunity, my lords, arose on the 9th of February, when this court allowed the petitioner to file all his old and new evidence. And this was during the application for amendment of the petition. The court, in its ruling on the amendment of on the application for amendment, did not find that the amendment was necessary, since most of the grounds which were in the amendment had already been pleaded in the opinion of court, apart from one new ground which had to do with qualification of the first respondent, which was time barred. My lord, court explicitly stated in its written ruling that all that was left was for the petitioner to adduce the same evidence for which the amendment was sought. My lord, this ruling was actually prejudicial to the respondents, because by doing so, court had allowed submission of evidence to support grounds that had not been particularized. They had been pleaded but not particularized. So it should have been the respondents complaining. But even with this golden opportunity that came on the 9th of February, no such evidence was filed on this date either. My lords, 2 days later, on the 11th of February, another opportunity presented itself when a pre-hearing conference was held by this court. My lord, on the 11th of February, the petition applied for an adjournment of the pre-hearing conference, and counsel stated on the record that he had 50 affidavits ready for filing on that day, that very day, and another 50 for Monday the 15th, and that would substantially form the gist of his case. My lord, court granted the adjournment and gave the petitioner up to 5 p.m. on 14th of February, the Sunday, to file all his evidence, which he undertook to do. My lord, no affidavits were submitted on the 11th of February, yet he had them and had undertaken to file them. My lord, instead, 53 affidavits were filed at the last minute of the last hour of the last day, 14th February, and even then with fewer copies than required by court. Only 7 were filed. My lord, this was 10 days after the petitioner had tried to amend upon discovery of new evidence. Court accommodated the fewer copies, notwithstanding that it offended the rules. This further accommodation too has not tempered the false accusations leveled at this court. Clearly, no good deed goes unpunished where the petitioner is concerned. Some of the affidavits that were filed on this day, on the 11th, sorry, my lords, on the 14th, are dated as far back as 9th of February. My lord, during the pre-hearing, the court was clear. The timelines were strict, and the registry would not receive late-filed documents.
You are left with 10 minutes.
Thank you, my lord.
Yeah.
My lord, notwithstanding this clear directive and order of court, the petitioner still sought to file extra volumes on the 15th after the expiry of time. Court was also clear when it stated that a party would be very lucky if an application to file an affidavit late was allowed. But on Wednesday 17th, we were here where the petitioner tried his luck, and not with 1 or 2 affidavits, but with 200 for which he sought the leave of court. The effect of this on the calendar of the court would have been very clear, because the respondents would need at least 7 days to respond to these allegations. And if this was taken out of court's time, court would only have 3 days to render a decision. This was clearly an attempt to try the case by ambush, or even worse, to fail a decision of the court. My lord, the applicant also filed the aforesaid application for leave to file extra evidence based on lies. The petitioner claimed that he had sufficient ground for enlargement that was premised squarely on a lie of the petitioner and his advocate, Counsel Wameli, to the effect that the affidavits were in court on 14th of February. So when your application is based on a falsehood as sufficient cause, what should you reasonably expect as the outcome? The application for leave also stated that his witnesses were in prison. However, this was not plausible, my lords, because the names of the detained were not mentioned in the application, and neither was proof of the detention availed. In any event, how can someone be a witness if you haven't interviewed him? How do you know what they have to say? How can security agencies arrest your supposed witnesses when you've not filed a list of witnesses to identify them? Because there's no unique sign that identifies someone as a Chagulani witness simply by looking at them. This was not a credible ground. The other allegation that was raised is that the petitioner's offices was under siege. But as shown, my lords, he had his evidence by 4th of February. So clearly the witnesses and the evidence were not in that office. Lastly, the petitioner claims that he was under the impression that affidavits in support could be filed at any time during the trial. My lord's court was very clear during the pre-hearing that timelines were strict and the registry would not receive any late filed documents. His counsel too gave the undertakings on 11th Feb that the timelines would be met. So who gave the petitioner the impression that code did not mean what it said? Or did the petitioner think that court orders are merely suggestions where he's involved? In any event, my lord, the allegation that affidavits, it's a practice for affidavits to be filed at any time is not true. So my lord, on the question as to whether the petitioner was afforded a reasonable opportunity to present his evidence in support of the petition, the clear answer is yes. The timelines were reasonable and the parties undertook to meet them. All these were reasonable opportunities that were squandered. The third question, my lord, we need to ask in order to establish whether the unprincipled noise that we are hearing is worth our attention is what is the nature of the evidence adduced by the petitioner. And in answering in this, here is where we agree with the petitioner, that the evidence that is on record is not sufficient to support the petition. Why? One, it is constituted by forgeries. The forensic document examiner, Ms. Sylvia Chelangat, in her affidavit, discloses that 10 out of 15 of the petitioner's affidavits that were examined, they are forged signatures. Petitioner in his application before the court today does not challenge the findings, but simply states that his witness's privacy is being infringed on. Firstly, these cannot be your witnesses if you have to forge their signatures. Secondly, the petitioner attached their national IDs to the affidavits that were produced to this court. So the issue of privacy does not arise. He's the one who infringed on their privacy by submitting their IDs. The petitioner, it appears, was given the impression that he has the right to present forged evidence and it is wrong for him to be caught, because his only complaint is that he was caught. This is impunity, my lords. My lords, the evidence also includes admission of offences. The petitioner, in his affidavit in support of the petition, takes us on a ride around the country together with about 100 of what he calls his personal journalists, campaigners, musclemen, sound engineers, etc. He holds press conferences with foreign media while on the highway, and he has people riding on the roof of his vehicles as he arrives at some venues, sometimes between 1 and 2 a.m. My lords, all these are serious violations of public health and road safety laws. My lords, the evidence also includes immaterial witnesses. Out of the 53 witnesses who were submitted to this court, 27 are constituency and district supervisors. A supervisor is not a candidate's agent. He's not at the polling station. He has no role to play in the electoral process where it is happening at the polling station. And he even has some of these supervisors coming from Busia, but they are supervising elections in Maracha. All they can say regarding election day is hearsay. So the only ground there, for my lords, on which we agree with the petitioner is that he has no chance of succeeding in this petition with the type of evidence he has adduced. And since the 53 affidavits are a sizable representative portion of his evidence adduced to overturn the election, is it reasonable to assume that the rest of the evidence that was left out bears no forgeries, no falsehoods, no admissions of offences, and no irrelevant matter? My lords, I think such an assumption would be unrealistic. My lords, it should therefore come as no surprise that the first respondent does not oppose the withdrawal, because the petitioner is playing a treacherous game which has no rules and which we are therefore happy to leave. He files when he wants, amends without leave, tells lies on oath, submits affidavits with forged signatures, and takes pride in subjecting the arbiter of this dispute, yourselves, my lords, to insult and public ridicule in the media. My Lord Chief Justice went to great lengths on 2 occasions to remind the parties about the seriousness of this undertaking. But with total lack of decorum and contempt, the petitioner held a press conference to announce his decision to withdraw the petition and launched another media attack on this court. Counsel Wameli was similarly on NTV, on the 23rd of February 2021, maligning this very court. The details are in the affidavit of Mr. Oscar Chihika in reply. All this scandalous conduct, my lords, is akin to verbal wars that we have only seen between rival singers. Yet this is a serious undertaking. My lords, 3 members of this bench have been publicly attacked because the petitioner states that he's not comfortable with them handling this matter. Then why not file a recusal? File for recusal formally. Why address this in the press only? Why not submit your allegedly overwhelming evidence on time to the court? Since the members, the 6 members who you are not averse to, are the obvious majority. Clearly, either the intention of the petitioner was not to advance an inquiry into his petition, or the petitioner's mathematics is as bad as his manners.
And so you concluding?
Yes, my lord.
Conclude.
Yes, my lord.
Your presentation, it is apparent that there are no grounds for leave. They have no substance. And yet you have gone ahead to concede. You have gone ahead to concede to the application for leave.
My lord, thank you.
What are your reasons for your concession?
Thank you, my lord. We concede that the evidence on record is not sufficient to support the petition, and this is contained in the affidavit of Ukasha Sekaja, paragraph 4. That is the only ground we concede. The rest of the grounds, my lord, we do not concede. On that alone, we're in a position to concede to court granting leave for the petition to be withdrawn. My lord, I would also seek to address the issue that was raised in the affidavit of Oscar Chihika, of the petitioner saying he's going to the public court. This is a very serious statement, because we all know that power belongs to the people, Article 1 of the Constitution, 1.1, but that very article states that it shall be exercised in accordance with the Constitution. Article 1.3, all state power emanates from the people who shall be governed through their will and consent. Article 1.4, such consent is expressed through regular, free and fair elections. And if I may add, not through mob action. The people express their will and consent, my lords. They exercised their sovereignty on 14th of January 2021, and the second respondent announced the people's verdict on 16th of January, returning the first respondent as president. So what then, my lords, is the public court? This is the public court, my lords. Article 2126.
Council, you have eaten your 20 minutes. I'm giving you 5 like I gave your learned friend.
I appreciate that, my
Make sure you conclude within the next 5 minutes.
My lord, I have an arrangement with my colleagues to borrow time. I don't know if court can allow me to borrow some time from them.
From which colleague?
From the second respondent.
Come again?
From the second respondent, my lord.
How much time?
5 minutes, so 10 minutes I should be done. My lords, 5 minutes plus my colleagues 5 minutes.
Now, my lords, you can see how they work together.
Well, they're all respondents. So you brought them together, Council.
My lord, we are sued together. If you sued us correctly.
What,
my lords?
As long as the other person loses the 5 minutes, is that okay? Huh? Yeah. So this is what we'll do.
Yes,
if you take the whole of their minutes, then we'll go to the third respondent. So whatever minutes you take from them, they'll speak less by that time.
Okay, my lords, I'll
Yes,
move
yes,
through
yes.
very quickly. My lords,
So you borrowed 5?
and my lord has graciously given me 5.
Yeah, no, because we interrupted you. So to be fair, I gave you 5. Now, if you take 5 from him,
Yes,
when we reach him, we'll speak for 15 minutes.
yes, yes, my
Or
lord.
not more than 15 minutes.
Yes, my lord.
Yes.
My lord, this is a public court because Article 126(1) of the Constitution states that judicial power is derived from the people and shall be exercised by the courts established under the Constitution in the name of the people. An attempt to talk of any other court would be to overthrow the will of the people. My lord, on 11th February, the court warned the parties against disparaging and mudslinging remarks, but as the affidavit of Chika shows that this has continued and needs to be curbed, my lord, the petitioner quickly forgets that he owes his political career to the court decision in Sitenda Sebalu versus Apollo Kantinti that enabled him to participate in a by-election in 2017. He also forgets that he's currently on bail in 2 matters before Gulu High Court and Iganga, the Chief Magistrate's Court. When his movements were restricted by the state, it is the High Court that he ran to. So it beats all reason and understanding that this is the same person viciously attacking the court. And of course, the petitioner is undoubtedly of modest exposure to the law generally and structured life outside music. But then what is the excuse of his advocacy?
I object, my lords, and I think I have been patient with my colleague, my learned friend, Mr. Karugire, in terms of the language he uses against my client. Civility and conventional practice would require that an advocate at the bar conducts himself in a befitting manner. If I started talking about his client outside politics or outside this court, I am sure there will be chaos in this house, in this court. May I invite court to restrain him in making disparaging references to my client.
Let's address ourselves to the evidence that have been adduced in this application, either by the applicant or by the respondents. And yes.
Thank you, my lord. I'm most obliged.
And second, for anything that has been said outside of what your presentation was, you have a whole 10 minutes of rejoinder. So you have an opportunity to
That's
respond.
correct, my lord. I am only objecting to what goes on record, which is an insult to my client. I also have enough about his client.
I have ruled on that one.
I'm much obliged, my lord. My lord, the law anticipates that matters of this nature will happen, and that's why Article 128(1) protects this court from interference by third parties, and also punishes consent. Contempt of court is also punished under Section 107D of the Penal Code Act. And this is in addition to the inherent powers of this court to punish people who act in contempt. This court should not turn a blind eye to this travesty. My lords, the sum of all this leads us to the conclusion that the petitioner has no evidence to support his petition, and the highest court of our land has been used as part of a political theatre, but not to resolve a legal grievance as the law envisages. We pray that court is pleased to grant the leave requested by the petitioner. We do not oppose the grant of leave, but we pray that it will be done on the following terms. One is a declaration that the first respondent was conclusively elected as President of the Republic of Uganda. This is a consequence of withdrawal of a petition under Section 59(4) of the Presidential Elections Act, where no petition is filed within the time prescribed under subsection 2, where having been filed is withdrawn the person who filed it. The candidate declared elected shall conclusively be taken to have been duly elected as President. Second, we pray, my lords, that the first respondent be awarded costs of the petition, and Section 64(1) of the Presidential Elections Act and Rule 27 of the rules, if a petition is withdrawn, the petitioner shall be liable to pay the costs of the respondent. This is the other consequence of withdrawal. We are aware, my lords, that in previous petitions the court has not granted costs. However, we submit that in those cases there was no withdrawal. So the above, the precedents which were stated by my learned friend for the petitioner are distinguishable. We submit that the specific provisions of the rules in respect of withdrawal creates a liability on the petitioner to pay the respondent's costs. Also, the conduct of the petitioner in this matter makes this a fitting case to award costs. My lord, Section 27 of the CPA, which gives courts discretion, is stated to be subject to the law. And the law here is Section 61(4) of the Presidential Elections Act and Rule 27 of the rules. Therefore, these two take precedence. Secondly, the cases discuss a petition, cases submitted by my learned friend discuss a petition that has been handled to its conclusion. And in that case, Rule 23(1) would apply, where court has the discretion to grant costs. That's Rule 23(1) of the Presidential Election Petition Rules. However, on withdrawal, Rule 27 applies, and it is specific. My lord, even if discretion is granted...
Conclude on your prayers now.
Fine.
You have just 1 minute to finish your 10 minutes.
Thank you, my lord.
Which we granted you.
Even if discretion was granted by the statute, my lords, with regard to costs, the petitioner fails the tests laid down in the own authorities. It has to be a genuine grievance that was brought to the court, not one of this nature. For these reasons, my lord, we pray for costs in the matter and for a certificate for additional counsel on record, given the importance of the matter, the difficulty, and the volume of work entailed. We so pray, my lord.
Yes, counsel. You have 15 minutes within which to make your submissions.
Much obliged, my lord. My lord, the Chief Justice, my lords, Justices of the Supreme Court, for the record, I am Ellison Karuhanga for the second respondent. My lord, I will begin by associating myself with the very able and erudite submissions of my learned friend, Mr. Edwin Karujire. My lord, the it is axiomatic that this court cannot force a petitioner to proceed upon a petition that he himself agrees is unmeritorious. So to that extent, my Lord, we do not oppose this application. Further, my Lord, we agree with the petitioner and associate ourselves with him when he says that no agreement has been entered into between the parties. So also to that extent, we do not oppose. We associate ourselves with Mr. Karujire insofar as he has listed the conduct. My Lord, we also wish, my Lord, to very precisely state that this Honorable Court's refusal of 2 applications does not show or constitute what Honorable Chagulanyi defines in his affidavit as impartiality and lack of independence. As officers of court, we feel enjoined to state that the averment of the petitioner in that regard is not correct. This court is under no obligation to allow incompetent, incomplete applications. So to the extent that the court is being accused of partiality in this very application, when in fact no such application...
Councillor Karuhanga, yes. I don't remember court saying they disallowed incompetent, incomplete application. I don't know where that one is coming from.
Much obliged, my Lord. Maybe if I rephrase, this court is under no obligation. Notorious applications or applications that lacked merit or that contained falsehoods. My Lord, the petitioner has elected to use a lot of his energy to argue that each party should bear its own costs. But his application makes no such prayer. He does not apply to this court to exempt him from the consequences of Section 61. In fact, he has only 2 prayers in his application. The first is that he be granted leave to wholly withdraw. The second is for costs for the application. There is no order or there is no request to this court that this court should not...
No, even that one is not correct. He does not ask for cost. He asked that cost be provided for, and you remember I reminded him, I went back to him for that purpose, and he says his prayer in the submission falls within provision of cost. That's what he told me a few minutes ago.
Yes.
He didn't ask for cost.
Yes. No, my Lord, I'm saying...
He pleaded with court to make provision for cost. And then when I tasked him, he said, the prayer now that each party bears, their cost, falls within provision of cost which I pleaded in the application. Yeah.
Much obliged. But my Lord, that prayer is about this application. There is nothing about the petition in that prayer. Section 61, because his prayer says costs of this application be provided for. Section 61(4) says that if a petition is withdrawn, he shall be liable to pay costs. So he has not prayed in his application that he be exempted, although he has made the prayer in his submission, my Lord, without amending the application, and he should be bound to his pleadings. My Lord, he has also cited two things, and I'll conclude on these two. One, a host of authorities interpreting Section 27, subsection 2 of the Civil Procedure Act, which provides that costs shall follow the event, including previous presidential election petitions. My Lord, those matters were not dealing with Section 61(4). Secondly, my Lord, he has brought the authority of Raila Odinga, where the court said that because of the way the IEBC in Kenya had conducted the election, that each party should bear its own costs. It's worth noting the distinction is that in that case, the Electoral Commission of Kenya had been found not to have arranged the election in compliance with the law, and the court annulled that election. So it's a distinction. He has also, relying on the affidavit of Sekaja Ukasha, talked about procurement and said that there was no reply to this averment. My Lord, it was an affidavit in rejoinder. There was no right of reply to that averment. It was also an affidavit in rejoinder that brought new matters. Mr. Ukasha had no right to bring new matters in a rejoinder. Thirdly, it was an affidavit by counsel on a contentious matter. Mr. Ukasha has no right to depone to a contentious matter. And fourthly, it is an affidavit about matters that are purely not within the knowledge of Mr. Ukasha, since he is not a procurement officer.
Council Karuhanga, was Mr. Ukasha's affidavit in rejoinder, or it was the second affidavit in support of the petitioner's application?
The one he's referred to was the one in rejoinder.
Okay.
Paragraph 4, he relied on paragraph 4 of the rejoinder. Which was, rather, paragraph 2 of the rejoinder, which was deponed on the 27th of February, after the application had been filed. To the extent that it is not a matter that was within his knowledge, it is a contentious matter. It is a new matter in rejoinder. That paragraph, my lords, we pray should be struck out. Is not for lordships. It's for the taxing master of any costs that would be applied. So, my lords, we associate ourselves with the submissions which have already been raised by the first respondent. And we pray, my lords, that this court be pleased to allow the application to withdraw, and that the requirements of Section 61, because what the prayer is that the court does not apply Section 61, because Section 61 subsection 4 is very clear. The petitioner shall be liable. The language that's used is mandatory. So we pray that, first of all, no reason has been advanced as to why, and secondly, that this court be pleased to grant the costs of this application. My lords, we so pray. The costs of the petition, not of this application, my lords. The costs of the petition.
Thank you. You've spared us 5 minutes, so we congratulate you for that. Learned Attorney General, can we hear from you for the third respondent?
Thank you very much, my Lord, the Honorable Chief Justice, and the Justices of the Supreme Court. The third respondent appears before you in this matter by way of an affidavit in reply that has been deposed to by the Honorable Jackson Kafuzi on the 26th of February 2021 and filed in this Honorable Court on the same day. and served on counsel for the applicant. My lords, again, on behalf of the third respondent, the law in regard to withdrawal of presidential election petitions, as has already been discussed here, is provided for under section 61(1) of the Presidential Elections Act, number 16 of 2005, which states as follows: that an election petition shall not be withdrawn, except with leave of the court, and after such notice has been given as the court may direct. My lords, the applicant has indeed sought leave of this court to withdraw this petition. And there has been no agreement of any kind with the applicant to withdraw the same. This is illustrated in paragraph 25 of Honorable Jackson Kafuzi's affidavit in reply to the application. My lords, the third respondent has no objection to the application to withdraw, except counsel for the first and second respondent, our only concern is that the grounds, or some of the grounds that are being relied upon, our only concern is grounds that are falsehoods, and that is why we feel duty-bound to point them out. For example, we have no objection to the grounds being relied on in paragraphs 1 to 5 of the application. The applicant, my lords, in his paragraphs 2, 4, and 5 of his affidavit in support, avers that the matters concerning his house arrest influenced his decision to withdraw the petition. Further, that he was not able to communicate with the outside world and could not instruct his lawyers after his release. As illustrated in our affidavit in reply at paragraph 4, his own advocate, Turiamu, and Mr. Zake Francis, his close associate, were communicating with him. So all we wanted to point out here was that that particular averment is not true. Further, my lords, it is our submission that much as it's the applicant's entitlement to withdraw his petition, he should not do it on the basis of falsehood. So that's all that we are saying. I think in answer to the Supreme Court Justice Aweri, who was asking that how come if you are in agreement and then you seem to be opposing. All we are opposing, my lords, is where the reasons given contained falsehoods, basically. The reasons, for example, that were raised in grounds 3 and 5 of the application were already raised. They were then submitted upon by all the parties, right here in this court, and the decision was arrived at by the Supreme Court of Uganda. So those were matters that were tried, and the decision was arrived at.
Can I ask one question?
Yes.
Now, Attorney General, what would the position of the law be, or what do you consider is the position of the law, where a petitioner seeks leave of court to withdraw a presidential election petition? The respondents are not opposing, as is the case now. Can court be inclined not to grant nonetheless?
I've thought about that, surprisingly, my lord, because it would leave the whole court in a paradox. Because if you have a person who is not ready to pursue his petition on the grounds that it is incapable of meeting the standards for the potential success, then he would be in a quagmire. He cannot continue because he knows he's going nowhere, and by his own admission, and he's the one in charge of preparing his case, has discovered that his case is not strong enough. I wonder what would happen if the court decided that he...
In effect, there would be no alternative except if another presidential candidate takes over.
Precisely. That would be the one opening. There was a threat, but I think it suffered a stillbirth. I don't know what happened to it.
We know nothing about that.
Thank you, my lords. So, my lords, it is our submission that much as it's the applicant's entitlement to withdraw this petition, well-known legal principles. That's what we're saying, which is very clear in the Presidential Elections Act. So my view is that regardless
in effect, you adopt Council Karugiri's submission?
By and large.
Okay.
By and large, yes. By and large, I do. My lords, again, at the expense of repetition, I already said, get it upon before this very court, and I'm saying that the right to withdraw does not allow you to reopen already concluded matters, and more so those that have been adjudicated upon in this case by the same court. But like you say, I associate myself with the first respondent's submissions. However, the ground 2, for example, where the applicant alleged that the Uganda Police and National Identification of Registration of Persons Authority were being used by the respondents to investigate and infringe on witnesses. The third respondent's response to this ground is contained in paragraph 17, 18, and 19, my lords, of Honorable Jackson Kafuzi's affidavit. And by and large, we are saying, well, if they are forgeries and they themselves attached national IDs, the law enforcement authorities are duty-bound to check. Again, learned counsel for the first respondent submitted on that. And this was premised on a reasonable suspicion that the signatures appended to the affidavits were forgeries. And the forensic document examiner actually found this to be so. So we just thought that that should be brought out. Then one that perturbed me, and I already spoke about this earlier on, my lords, the applicant in paragraphs 14 to 19 of his affidavit in support for withdrawal makes these averments that the court, in his opinion, was handling the petition without exhibiting independence, partiality, and giving all parties equal rights before it. It is the third respondent submission that, of course, the applicant was given an opportunity to be heard, and that the decisions of the court were founded in law. Therefore, to allege that he has been denied substantive justice on the sole grounds, it would appear now, that the rulings were not in his favor. That's not the same as saying that the court acted with independence or without independence, without partiality, and didn't give all the parties equal rights. But this, we traversed it a long time ago, my lords. I think I would hope that this court will make the appropriate findings on that. These averments we find unfortunate, and I really don't want to belabor this because we went through this. We find them very unfortunate, without merit, and now to come out at this stage of the presidential election petition, at the point when you are withdrawing, we find that that was not in good taste. We hope that the applicant is advised that parties come to courts of their own free will and do so in their quest for justice and finality of matters. But once they do so, once you come to the court, like I said, we have already traversed this, you should abide the rules of the court and must desist from the kind of gimmicks and brinkmanship that we have been made to endure. But again, like I said, you come to court, then you must abide court. This is the first time we have a candidate for the highest office of the land coming to court to seek justice and then turning around to cast aspersions on the same court. That's where you have gone to seek justice, but that's where you are casting aspersion. I think this type of conduct should be castigated. Never mind, my lords, that we are reminded that the same applicant has severally sought court's intervention. Commission, my lords, just for you to take judicial notice with your permission, I would like you to take judicial notice of 2 cases in which the petitioner applicant, in particular, has used the courts to seek redress in his favor. In the case of Basil Difasi and 3 others, versus the National Unity Platform and 9 others. The National Unity Platform, of course, is the political call for the applicant. Miscellaneous clause number 226 of 2020, His Lordship Justice Musa Sekana, in his judgment on the 21st of October 2020, where court validated the nomination of the applicant petitioner as the flag bearer of the National Unity Platform for the position of presidential candidate. I think the allegation there was a group trying to steal the party, but the petitioner came to the court and the court said no, the other group was wrong, and it said you are the rightful owner. I think that's one clear example of successful petition to the court. Also, in another one, Senator Robert Chagulanyi versus Attorney General and 2 others, this is miscellaneous clause number 16 of 2021, His Lordship Justice Michael Elubu, this is on the 23rd of January 2021, found that the confinement of the applicant in his home was unlawful and ordered the restriction to be immediately lifted. It's another example where you have gone to the court and court has done you justice. That's why we find it rather ironical.
Honorable Attorney General,
yes.
It appears the examples you are giving are not from this court. The complaint by the petitioner is his treatment by the Supreme Court in this particular petition. So it's for the other incidences where he was treated very well by the courts.
Oh.
I think that's what I gathered from this application.
Well, I'm not sure about that, my lord, but the structure, as we all know, starts from down there and ends at the Supreme Court. I would find it ironical for one to find one segment of the court to be correct and the other one not to be. I will leave that to your own interpretation, my lords. So we maintain our position. We do not object to the withdrawal of the petition. With Honorable Segona, we agree with you that in the fourth ground, that in your fourth ground, in our opinion, that evidence adduced was insufficient to sustain a successful petition. We agree with you on that. We submit.
Let me ask this.
Yes.
Any of those evidence contained in the 53 affidavits, and any of them pertain to what amounts to electoral offense, in which case you don't need to prove and have a presidential election overturned?
Yes, you only need one, my lord.
Yes.
And that is why this court allowed him to file extract affidavits, or if not, that the affidavits before it were sufficient. What they needed to do was to test the evidence, and had this petition proceeded, what we would have proceeded to do, to make our case about why we thought there would have been no electoral offense committed. And also that the first respondent, now I'm talking in the context of section 59(4), should be declared as the duly elected president of the Republic of Uganda. That is in accordance with section 4 of the Presidential Elections Act, that provides that where no petition is filed within the time prescribed under subsection 2, or where a petition having been filed is withdrawn by the person who filed it, as is the current case, or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected as president. My lords, we further undertake that in accordance with Regulation 23 of the Presidential Election Petitions Rules, no agreement or terms of any kind has or have been made, nor any undertaking in relation to this petition between the third respondent and the applicant. Now lastly, my lords, on behalf of the third respondent, and in line with section 61(4) of the Presidential Elections Act and Rule 27 of the the presidential election petitions rules regarding costs. Now, counsel for the first and second respondents, my lords, have submitted quite comprehensively on this specific prayer. I find no fault with their submissions on that. I associate myself with them, except that, of course, this particular item gave me quite some thought, especially in my capacity as the AG, because on the one hand, there's the desire to have the petitioner and or his lawyers to be condemned in costs, not necessarily specifically because of the withdrawal, but also because, in my opinion, of their general conduct. Of course, under the law, there is provision for that, but just the general conduct as well. The false averments, the media theatrics, the denigration of our temple of justice, this court, the double standards I just referred to. I stand to be corrected by Justice Araj, because I was saying that one morning you are in a courtroom seeking to salvage your party from some people you describe as unscrupulous. On another day, you are seeking your freedom from the police.
My lord, on the word unscrupulous, I strongly object.
No, I'm talking about, well, this was in the courtroom. I'm talking about the people from whom I said he was seeking to salvage his party from some, he was saying, some unscrupulous people who wanted to take the party. I'm not saying that the petitioner is unscrupulous. The petitioner was saying that there were some unscrupulous
my lords, to the extent that certain allusions are made with reference to my clients, and trying to create a huge distance between a petitioner who is in this court and the court. That's the basis of my objection.
Councillor Bega, I think you're not following what the learned Attorney General is saying. You see, it's been your case. You've set out, you've laid grounds for seeking withdrawal, and the respondents responded. And among the things they brought forward is that I'm paraphrasing, the petitioner used both the court forum and outside his petition. That's really what they are saying. And if I understand the respondents, they're saying, because of all this is not one of those cases where the parties should bear their own cost. The petitioner should be condemned to pay cost. Whether I agree with them or not, I don't know. I will have to consider all these things. But and if you look at their affidavits and what have you, they list down some of the things which have been said. I don't know what you think about those. Yeah. But as I said, you have your 10 minutes to respond.
Yes.
And set the record right. If you think it will go down on records.
Okay.
Yes.
Okay. Most obliged, my lord. So I was just saying in conclusion, I thought that point I had made was crystal clear. But
you can conclude now?
In conclusion,
yeah.
Yes, my lord. This is what played out in itself in my mind for me to think that if there was a time when opponents should be slammed with costs, I was thinking this was such a time. The thing is that
but learned Attorney General,
yes, my lord.
Honestly, I don't know what my view will be about cost. And there are remedies for utterances and becoming utterances. If anyone, forget the petitioner, if anyone who's come to court has made either in court, this court dealt with a situation where somebody came to court and made unthinkable utterances, something we've never seen in this country before. If somebody makes utterances which offend the courts, either in court or outside, then there a different remedy provided for under the law is cost the appropriate response by court.
Thank you, my lord.
Yes.
And it was actually part of my conclusions that despite all that, yeah, I juxtapose this first of all against my position as the head of the bar, then the issue of the national importance of this matter that we are in agreement with our citizens, And also, my Lord, I considered the advice of this court earlier that my office consider setting up a forum for the interaction of lawyers, especially senior ones, to discuss our general conduct. So I juxtapose this and the need to temper my initial instincts, the one we were just talking about now, to demand for costs. And then I came to the conclusion, my lords, my lord, this is precisely what you are saying, that I leave this matter to this court, asking the petitioner to toe the legal line. I agree with you that this court must find some way to decide on how best, in these particular circumstances, to bring the petitioner to...
We would have loved to see the Attorney General not sitting on the fence. He'll come out and say, despite all this, please do not award cost. Because of all this, we think this is a situation where court should award cost. Whether we'll agree with you or not, but I think we would respect. Like all these submissions you made, we respect them. But whether they persuade us or not is a different matter. That's what I thought. I'm not saying you should change, but that's what I thought.
Yes, yes. I would like to maintain that, because you see, my lords, like I said, as far as I'm concerned, this particular case, with its circumstances, is the right type of case for which costs should be awarded to the respondents. I was just expressing to the court my dilemma in the context of what I've already said, the citizenship, and saying that I would therefore leave it to this honorable court, seeing that you have all been, you have also seen all the circumstances of this case, to come up with some manner of sanction to allow petitioners to know that once you come to the courtrooms, you must toe the legal line. Therefore, my Lord Chief Justice and the Justices of the Supreme Court, we pray the application is allowed, the petition is withdrawn, and that's what we beg to submit.
Thank you. Councillor Meda Lubega, you have 10 minutes within which, and please press us on new matters that are raised.
Thank you, my Lord. Like my learned friend, Mr. Edwin Karujire, having adjusted my height, permit me to put the microphone up, because it seems to be shorter than me. My Lords, with by counsel for the first respondent. First, I am glad that the application to withdraw is not opposed, except for the reasons. On that alone, I invite your Lordships to find pleasure in allowing the application. Number two, with respect to the alleged falsehoods, as well as many reasons given by counsel for the first respondent to disadvantage or disable the prayers that we have made, I have the following to say. One, it is within the right of a petitioner stroke applicant to express himself to court on his feelings. One thing I do not and will never condone as a lawyer is attacking institutions that guarantee the safety and tranquility of the country. I have stated at the bar before, and I continue to do so, that whenever given an opportunity, I shall provide my professional voice, whether client or any other person. But permit me also to submit, as I've submitted before, that the allegations against the applicant are so grave in nature, to the extent that they are touching the relationship of a litigant and this court, a forum he chose to come to. Whoever is making these allegations ought to have done more. When you make reference to a press conference, there is documentary evidence that you can be able to procure. The same respondents who are able to go get a one chelangat from the police, go to NIRA, which is the Department of State, and bring it to say that the signatures presented by the applicant are forgeries, even without producing the people who signed or are alleged to have made those signatures and supplied their declaration, their national IDs. It is so disturbing that such a person cannot procure a recording from a TV station which he claims to have witnessed, and therefore simply comes to soil the name of an applicant in a bid to recruit sympathy from this honorable court. I am fortified that this court has emphasized before that it's not going to be guided by rumors, but rather evidence presented here. My lords, yes, the applicant stroke petitioner.
Councillor Bega.
Yes, my lord.
Thank you for that part of submission. I agree with you. But can I also ask that if such evidence were used in the manner you're saying, they were proven, they can lead to very serious legal consequences. Now, I'm only saying because you raised it. For us, we're determining the matter of withdrawal, and we're not dealing with the other matters. They have only raised it to deny the grounds you've given for withdrawal. But it's not a matter for trial within us, before us. But you appreciate that if such evidence were brought before any court, as they allege and proven, they lead to very serious consequences. As a lawyer, you are aware of that.
I have two answers to that, my lord, with your permission.
Can I supplement? There is Oscar Kihika's affidavit, paragraph 30 and 31, which talks about the same thing. And you have not replied to it.
My lord, I thank you again. I have previously, in a similar allegation, made submissions with respect to Mr. Oscar Kihika. And that's why I said, you have no reason. Why? Because there is a way of presenting conclusive evidence to demonstrate that actually the applicant is as errant as he's being portrayed. My lord, with respect to the question from my lord CJ, the serious consequences, and that the matter is not before this honorable court for trial, but to consider whether to grant or not to exercise your discretion. First, I reiterate the first answer of the veracity of this, which is hanging without an attachment. The consequences, yes. As a lawyer, I know. As a lawyer, I know to give due respect and treat this honorable court, not only this court, but any court or institutions of state, with decorum. As to whether this should be used or applied or looked at in the exercise of the discretion, that's why I'm submitting no. Why? Because it is left hanging. You have no reason to believe this affidavit of Mr. Oscar Kihika that the petitioner stroke applicant is in the conduct of disparaging and disrespecting court. If anything, the evidence supplied by the Attorney General, which I agree with, my client is a regular user of the courts of law in this country whenever his rights have been transgressed upon. That is a demonstration that he believes in the rule of law and not jungle law as he's being presented. I mean, there is evidence on record.
You know what the learned Attorney General said, I think the other person said, that your client is only happy with court if the court rules in his favor. The moment the court rules against him, then the courts and the other words I can't repeat. You know
Like,
what they are saying.
that's what he said, but I'm giving the proper context, my lord. And the proper context in our humble submission is that in the rule of law, that's why whenever brutalized, whenever transgressed upon, he runs to the same court. He's not running to anyone else. What the effect of the submission from the respondents, from the bar.
But when the court rules against him, then he goes to the People's Court. That is the final court now, above the Supreme Court. That's really what it means.
In my lord, in the honest belief that you have not believed that rumor, my lord. I know.
Councillor Bega, I want you now to address us on other things. But let me say this. As a Catholic, people pray a lot of things. For me, Jesus said, we say the Lord's Prayer. I say it twice every day.
Yes, my lord.
And the one which I remember, it says even God should not lead us into temptation. I think do not lead the Attorney General, who has said he wants to organize a meeting, which is a very good thing. Don't lead them into temptation. Because for me, I would want this matter to remain where.
My lord, I treat
and we do our things.
with immense respect, my lord, to the Attorney
Don't
General.
emphasize that area that bring proof.
No, I think
could be brought. I don't know unless they are lying.
my lord,
that's why I was helping you.
May
Don't
I pray?
take that route. Let us conclude this matter. Whatever has happened, let me repeat this. Then you continue. As the judiciary of Uganda, which I heard, we were never influenced by people who praise us or people who abuse us. You can abuse the Chief Justice, you can abuse the justices of the Supreme Court or the entire judiciary. But when you come before us and you're on the side of the law, we will protect you, the insult you have heaped on us notwithstanding.
My lord, that gives me comfort that actually you are not aware of those insults because they do not exist. And if they existed, you would have evidence before your lordships.
I think if I may advise council, why don't we restrict ourselves to the matter before us and avoid extraneous matters?
My lord, that's my prayer.
Okay.
And that's why I said that the matters placed here are extraneous to the extent that somebody simply comes to say, this man said he's going to the People's Court. I agree with the counsel for the first respondent that this is the People's Court because it is established in accordance with the Constitution to exercise jurisdiction in accordance with the aspirations of the people of Uganda. As to whether, my lords, that is the perception of either the petitioner, the respondent, or other people outside is not a matter for this forum. Like I did make an undertaking, anything that ridicules the independence and respect of this court, I stand with court.
Proceed.
Thank you, my lord. With respect to cost,
record on that. Yeah.
Thank you, my lords. I think something again prejudicial has been said about the petitioner and his advocates. Let me repeat. As advocates, we have done our work in accordance with our professional training and orientation. My lords, a lot has been said in the background. May I invite court to look at that as a background, notwithstanding interpretation on the part of the parties. But the essential elements to satisfy you in exercising your discretion have been satisfied and played for your lordships that there is good cause to withdraw, to allow the withdrawal of this petition. I think a lot has been said about costs.
Conclude in 5 minutes.
To cost and prayers. First, there is no admission of offenses. Coaction by a person who is being strangled before this court and trying to look for evidence to extricate himself. I believe it was within the right of the respondents to extricate themselves. But to the extent that they refer to the signatures as forgeries without bringing conclusive evidence is also very, very unfortunate. My lords, on the prayer by the respondents that you be pleased to therefore declare in accordance with Section 59 of the Presidential Elections Act that the first respondent was duly elected. The guiding law is subsection 4 of Section 59. 1. It reads, where no petition is filed within the time prescribed under subsection 2, or where the petition having been filed is withdrawn by the person who filed it, or is responded, or is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected. You do not need to make a declaration. It is not within your power. It will be up to the person was already declared by the Electoral Commission.
What does the law say? The law cited by Council for the
there are two provisions, and I want to read both of them.
Please do.
5. After due inquiry under subsection 3, the Supreme Court may dismiss the petition, declare which candidate was validly elected, or annul the election. Now, your power to declare comes into play under subsection 5. After you have had due inquiry into the petition. The process in subsection 4 is purely a political process. It is up to the respondents to say, since the petition has been withdrawn, therefore this man was properly elected. For you to order or to declare that the first respondent was duly elected, it can only come under 5 after you have inquired into the petition, which for now, if you permit the withdrawal, you have not done. My lords, finally, on the issue of costs, I reiterate my earlier prayers, but let me conclude with this particular extract from the decision of Justice Sekoko, JSC. In our bundle,
do that in 2 minutes.
Thank you, my lord. In our bundle, pages 17 and 18, it is express. My lord, this is election petition number 1 of 2001. He says, even if, and quoting the Indian authority of Charan Lal Sao and others versus Singh 1985 LRC, page 31, that even if the election petition was frivolous, court should exercise its discretion not to award costs because of the public importance of an election petition.
Does that cover even a vexatious one?
It does.
What your learned friends are saying in their response, I'm not saying I agree with them, but what they're saying is that the petitioner was both vexatious and frivolous. That's really what they're saying.
My lord, that will take us into the definition of both phrases, vexatious and frivolous. One which does not disclose on the face of it reason for inquiry. If that was the kind of petition we presented, it would even have been one either rejected by the registry or struck out by way of a preliminary objection.
No, that would be on cause of action. You can have a cause of action, but you can still be very vexatious and frivolous.
Yes, my lord. In this case, we submit it was not, to the extent that it demonstrated.
No, what I wanted to know,
yes,
it would cover both situations.
It does. It does. Even champ to us causes, my lord, it would be covered. My lord, the second respondent has submitted that Ukasha Sekaja does not have.
You remember you had 2 minutes only.
I'm now using the last one, my lord.
Yes, yes.
Does not have knowledge of the procurement issues. The first thing is, what does the law require? The law requires a procurement process which is public, including an advert, for all lawyers who may wish to supply. It is no record that it was done. My lord, the authority I referred to, which I invited you to adopt and find persuasive, of Justice Musota, involved the same law firm of Kampala Associated Advocates, of procuring legal services. There was an opportunity. It is not true that they could not respond because this came by way of rejoinder. The practice of court is that there is even a subjoinder, there is even an affidavit in rebuttal. There is even a provision for somebody to apply for leave to respond to a particular averment. It is also not true that this is so contentious. No. Every lawyer knows the procurement processes and laws in this country. And I want to assume lawyers that really went through law school. And Ukasha says, I know that this process was not followed. It is illegal, it is irregular, it involves the same.
Okay, I'm trying to understand. So your point is, even if this court were inclined toward cost, then the council, the provision for instruction fee and the other costs which are attendant to council's participation and so on should be excluded.
They would not be entitled to a coin.
But that does not mean the second respondent, is it second? Yes.
First, the first and second.
Oh, it doesn't mean they will not be entitled to cost.
No, it doesn't apply. In my submission, I said specifically with respect to the second respondent.
But that's what I'm saying.
Yes.
Would it mean the second respondent would not be entitled to cost, or if it is being taxed, the lawyers who have represented it here will not be entitled to cost?
My lord, that's why I submitted that to the extent that the procurement was illegal. Now, the second respondent, which costs would he present? Would it present? And this was in specific reference to the affidavit of the Honorable Stephen Tashobi.
The second respondent, counsel, the second respondent is here in the person of
Honorable Stephen Tashobi.
Commissioner Tashobi, yes. I mean, I don't know. Maybe the other. All that I need to know is.
My lord, you're referring.
Are you saying whatever other cost, inclusive of hiring counsel, they will not be entitled, or are you saying whatever other cost which can be permissible, if court is inclined to award cost, they would get it, but not for hiring.
I'll give two answers in the alternative, my lord.
Yes.
The first is that they would not be entitled to anything for having engaged in an irregularity and illegality. But in the microscopic event that you find they should get something exclusive of the instruction to advocates, then I would concede to transport to Commissioner Stephen Tashobi.
No, that's not for us.
As a disbursement.
Councillor Lubega, you can wind up now. So what is your final prayer?
My final prayer, therefore,
reiterating your earlier prayer.
To reiterate.
We are not taxing master.
No, my lord. I am talking about the denial in principle that the taxing master should not even entertain a bill from the second respondent. Finally, my lords, we have mentioned that my colleagues who counsel for the first and second and third respondent have submitted, and I'm ending up, that that the provisions of section 64 with respect to liability to...
You would begin by asking me for more time because it...
My lord, may I be granted half...
I'll give you 2 minutes.
Thank you, my lord.
Please conclude. Half a minute, you would yawn and get finished.
With respect, my lord, to the question of liability to pay costs as per section 64. Liability to order costs simply means this honorable court has the discretion. Yes. It is not mandatory submitted by my friend Mr. Edison Karuhanga that where they say shall be liable to pay costs, it is mandatory. No, the word liability connotes that discretion. The word shall itself, it is not mechanically mandatory as he thinks or he seeks to submit. Authority, my lords, number 5.
What is mandatory in that one would be the liability.
There is nothing mandatory in that.
If you say shall be liable,
yes.
What is mandatory would be the liability.
No.
Not the cost.
No. What is mandatory?
Not the suffering of cost.
No. Nothing is mandatory in that, my lord. And the authority number 5 is a decision of this court, Sitenda Sebalu versus Sam Kenjuba, on the Electoral Commission. This honorable court, and my lords, I refer to to pages 50, specifically page 55, on the interpretation of that word has been made. And that's why, my lords, even in previous petitions, you have not awarded costs. I pray that you continue to exercise your discretion judicially.
Yes, because it is mandatory for court to exercise discretion.
Obliged, my lord.
On issue of cost.
Obliged, my lord.
The discretion, it is not something they come and say, we have awarded cost.
May I rephrase that? Yes, it is
exercise
mandatory.
Of discretion, it has got to be done judicially.
True, my lord.
You know the law on this.
And that's why I'm saying, my lords, and I emphasize the word that you continue to exercise your discretion judicially.
Thank you, thank you.
I so pray.
Thank you so much. Yes. Oh, sorry. I think there's a question from my learned
Council Segona. There was an authority which was supposed to be roasted. Where is it in the process? Have you abandoned it?
No, my lords. After roasting
where
it,
is the registry? I think one of our
my lords, after roasting it, it could not come back to the same suspiciously contagious hands
no, it was
of the lawyers.
By the registry.
But is it on the record?
I believe yes. We filed it in the registry, and
okay.
It is. If it is not there, my lord, it is in transit.
I think it's okay. That's the first question.
Yes, thank you.
Then I have a question for counsel for the second respondent, Counsel Karuhanga.
Yes, my lord.
You submitted that, and I'm glad it has been touched on in the rejoinder, and the court has also, talked about it earlier. That paragraph, the amendments in the counsel for the applicant's affidavit regarding the issue of procurement and not within the person, the counsel, and therefore they should be struck out. That's what you submitted.
Yes, my lord.
So my question to you, my reading of averments in this application, and I think we had considered in this application, there are many other averments which fall in this category. Is it your position that courts should simply strike them out?
Sorry, my lord, there are many other, I didn't get the...
averments which have been made, and time does not permit us to go into them, which would seem to fall in that category. Sown yes. by
Ukasha Sekaja, my lord.
Yeah, no, the ones sown by Ukasha, your submission was that they should be struck out for they not being within the personal knowledge of the person deponing.
Yes,
so my question is that, is it also your submission that the court should apply the same standard to any averments where deponents have deponed matters that are not within their personal knowledge?
My Lord, I think if I can just...
No, with respect, for example, to your client. Because I'm going to ask the same question to the second respondent. Is that your position?
Yes, my Lord, our position is that the law governing affidavits is Order 19, Rule 3. In that particular affidavit, he deponed in his capacity as counsel for the applicant and said he knew about certain processes of the second respondent and did not show how he knew about them, where he had been informed about them. If there is any other affidavit that contains information where
from the respondent,
does not show that he knows how where he does not disclose the source of his knowledge or how he obtained it, it would certainly violate Order 19, Rule 3 of the Civil Procedure Rules. I think the ultimate principle is where a deponent is giving us information that the deponent surely does not know, like Mr. Sekaja does not know, then we cannot rely on evidence that a witness giver surely does not know. As opposed to someone who said, I had...
No. So you agree with me that that's a rule of general application. It applies to averments by the applicant, and so it also applies to averments by any party from, the respondents.
Yes, it applies. I'll speak for the second respondent, my Lord. It would certainly apply. If you find evidence of ours, which our witness didn't know, my Lord, please strike it out.
Thank you. So that takes me now to the Land Attorney General. You submitted, and this has been consistent, but in this application which is before us, if I may recall, that the averments of the applicant that he was restrained and could not prepare for his case were not true. And your evidence in support is the affidavit of the Land Deputy Attorney General, right? Which shows that the applicant was able to access, and you mentioned two in particular, his lawyer and his close associate. Okay? So my question is that if the applicant says I was not able to access whoever and the Attorney General within the personal knowledge, okay, of who the applicant could have wanted to access to prepare for his case, was that within his personal knowledge?
Thank you very much, my Lord. If we look at paragraph 4 of the Honorable Kafuzi's affidavit,
yes,
in reply to the notice of motion, that is where he states that it is not true that the applicant's mobile numbers were disabled as alleged, that I know that the applicant's advocate, Turiamu Sima, Geoffrey and Zaki Francis, a close associate of the applicant, disclosed in their affidavits that they were communicating with the applicant on his mobile phone during the time when his movements were restricted. His basis was a disclosure in their affidavits.
Yeah, but you used this, the concern I have is that you use this statement to make a general claim. Because the reason, one of the reasons the applicant is giving is that he gave the reasons why he couldn't, he's withdrawing, right? And part was the inability to access, which has continued to be, has continued to resurface. It resurfaced in their application for amendment. It is for leave to file, extension of time to file additional evidence, and it has also resurfaced here. Is that correct?
The question of his restriction?
Yes.
Yes.
And your answer has been consistent that you are relying on the the averments of the land Deputy Attorney General. In one of them, a list of saying, yes, he accessed his lawyer and he accessed a closed share.
Yes.
So my question is, that statement, the accessing the lawyer and the close associate, is that sufficient made here that the applicant's averments about the effect of his, the restriction, the 10-day restriction, had an impact on, it's one of the reasons why he's saying he's withdrawing?
Well,
is there is it right to transfer, access to one person to say, because of this, therefore, he had access to everybody. He wanted access. Prepare his petition.
Well, all we were doing is that...
Because those are your submissions, the Land Attorney General.
On which I have already told you, my learned Justice, that the averment in Honorable Kafuzi's, I've told you his source of the information, is the affidavit. And that was in response to the fact that he did not have contact with, to give instructions. So I'm saying that on the contrary, and by his own affidavit, he had contact. That's all that I'm saying.
But does the law say that an intending petitioner, once they have contact to one or two people, that is sufficient? Is that the law? Can you cite any provisions
well, I don't
on which
know,
you are relying on to make that assertion?
But I don't know whether a law gives a number of how many there must be.
No, my question is, do you have any law to make the assertion that if a petitioner says, I was constrained and couldn't access whoever I needed to access to prepare for my petition,
well,
then the Land Attorney General says, no, you had access to two people. One, your team, which you instructed, and the second one, your close associate. Do you have any basis, legal basis for making those assertions?
Well, the basis that we have is that he had contact with his associates and his lawyers. That's the basis that we have.
Okay.
For example, he made some averments that his witnesses were abducted and harassed. Like I already said, he does not provide any evidence of who these persons were, of various offenses. He does not give any evidence of the names of the people who were detained and therefore who made it impossible for him to present his case. Because had he done so, then we would have had the opportunity to controvert. That's all we're saying, my Lord.
Okay. So, anyway, I think I've had the answers I needed. Thank you, Land Attorney General. So, yeah, thank you.
Any other person? Okay. Thank you, Landed Council, for the parties. We've been consulting within ourselves. We'll leave a short ruling, which will be read out by Lady Justice Araj Amoko. Yes, my Lord.
Thank you, my Lord Chief Justice. This is the ruling of the court. Upon careful consideration of the application, the supporting affidavits, the Nation Land Council for the parties, the authorities relied on, and the law, and considering that the respondent's objection to the application for withdrawal, leave is hereby granted to the petitioner as prayed, and the petition stands withdrawn. The reasons for allowing the withdrawal and the reasons and the determination of the issue, of course, shall be contained in a ruling to be delivered on notice. This ruling is signed by all members of the quorum. Thank you.
Learned Attorney General, while my lords signed this document, the ruling, you brought up a very important matter that you'll be having a sitting, some forum with council, not just council here. I think you should include members of the press as well. The reason we have this fully covered is because this court belongs to the people. Everybody who cares to know what is happening in this court and has the opportunity should be able to follow, even from their sitting rooms, offices, their joint, and so on and so forth. So it's really important that for the good of the rule of law, for the good of due process, respective responsibilities, we as the judiciary, officials of the court like Learned Counsel, then members of the media, who have the responsibility to let the people know correct factual information on what is really happening in court. Because that's the only way we can do justice in all the matters that come before us. So in that thing, please, widen the catchment area should be wider. Thank you. Yeah.
Happening now. Tutaataganya mu mpeereza yaffe okukutuusaako ebyakagwawo. Happening now. Soul Television, Femunyo.